Please. But Mr. Patwalia is in another. Yes. What happened? No, I just started addressing your lordship on the two decisions, Vikas Shankla and Pradeep Kumar. May I continue? Lord, your lordship recalls what the issue was. Yes, Pradeep turned on. He has argued saying that Pradeep Kumar turned on the fact that it related to outsiders' claim and benefit. Yes, I'll show that right. I'll show that right. It's not so. There were two issues before this court, and both were decided. One was outside, and one was purely issue of migration from the reserve category to the open category. Just one fact, just to recap, all the petitioners are from the reserve category, and all of them have passed the TET, that is, the teacher's eligibility test, with a concession in the percentage of 5%. But you made a point. Yes. So, 60% is the normal pass, mark for all persons in the open category. There was a concession of 5%, for the reserve category. So, all of them, have. Where is the bar? Pradeep Kumar, you are relying on Pradeep Kumar. I am relying on Pradeep Kumar. It distinguished Pradeep Kumar. Whole case is based on Pradeep Kumar. Their whole case is based on Vikas Shankla. Would your lordship just keep few paragraphs of Shankla, then I'll take your lordship? So it's ultimately 5 minutes. Yes. If your lordship say that Shankla applies, then I'm out. If your lordship say Pradeep Kumar applies, matter ends. So these are the two things, my lord. First class. Sir. We see only these two judgments. That is all. 2017, one SC 5 recent judgment has come. Justice Dipankar Datta. Justice Dipankar Datta recent judgment. They said that this is a qualification. Those who has taken in the benefit in the TET, you cannot bar for the. You take cumulative marks, right? No, we don't take it. Then in Shankla, right? In Shankla, my lord, in Shankla's case, they considered the marks in the TET, they gave weightage to that. That's the difference. In Pradeep Kumar, no weightage was given. It was only treated as eligibility. That's all. And in this case, no, my lord. In this case, here also it's the same. In this case, without giving weightage of marks obtained in qualifying examination, yes. Is it not correct that they are more meritorious than? No, because then, my lord, if weightage is not given, it means that they appeared in the TAIT only because they had a concession. Otherwise, they would not have been eligible. And that is Pradeep. That's exactly Pradeep. If I'm right, my lord, that's exactly Pradeep. Pradeep says that he's turned on the ground that it is. So, my lord, in both decisions, migration, in both judgments, this honorable court, my lord, inquired. The only inquiry was of Pradeep Kumar to give it. My lord, the inquiry by this court in both cases, my lord, was to see whether there was a concession taken with regard to eligibility in both cases. Anyway, you complete your argument. Yes, my lord. So my submission is that in both cases, this court, my lord, inquired. The scope of inquiry in both cases was whether the petitioners who are from the reserve category, whether they availed of any concession for the purpose of appearing in the exam, the second exam, that is TAI. on the basis of which recruitment. In both cases, that was the inquiry. In Shankla, the conclusion was that there is no concession because weightage was given. In Pradeep Kumar, the conclusion was that there is concession because no weightage was given. That means, my lord, in the second stage, what did you say? What is the scope of inquiry? Whether there was a concession taken with regard to the merit for appearing in the second examination.
Capability to take the second examination arose because of the concession.
Because of the concession. And these are not cases, my lord. There are situations where concession is with regard to the fees or with regard to age. This is not that. This is directly on merit. That means, my lord, if they had not got 60%, they would not be eligible. Because they were allowed to get 55, they became eligible for the second examination. That was the teacher's aptitude and intelligence test. Otherwise, they were not entitled to even appear in that examination. Now, having taken the concession, this court has said, my lord, in Pradeep Kumar, that then you cannot be allowed to migrate to the open category. Then you must stick to the reserve.
Was it that the last time you indicated that the marks that they obtained in PET,
yes,
but for the reservation that they claim, they could not have been eligible to take the TAIT.
Yes, yes, that is admitted to. There is no dispute on that. That they all are below 60%. They are between 55 and 60. If they were above 60, then they would have qualified in the open category. There was no need for
qualifying.
Yes.
If it's a qualifying,
if it is a qualifying eligibility criteria, then, my lord, it affects the merits, it affects the level playing field.
It is meritorious so far as the TAIT is concerned.
But that is only because they were able to come in on 55%.
Would bar them at the entry
level. There was no question of them even thinking.
Want to bar them at the entry level.
That's right.
It was from President.
So,
last time he was distinguished.
Lord, may I show your lordship Shankla?
Distinguished. Yes, sir.
Two paragraphs. My lordship, please.
Yes.
May I just recapitulate a few paragraphs before my friend starts?
Not
because then he will know the point to me. Because what is being projected is a little different from what my sister said.
Which is the portion you want to read?
Lord, first, would your lordship just see paragraph 8, Lord, of Shankla?
NCT.
Yes, Lord. Lord, the second sentence, apart from other educational qualifications prescribed therein, said notification also mandate.
Wait a minute.
Yes. Para 8. NCT fulfilled. This was pursuant to the.
You are reading Vikas Shankla.
Yes, Vikas Shankla.
It begins NCT fulfilled. Yeah,
yes, that's right. NCT fulfilled this obligation in the Gazette of India under the RTE Act. They would take steps. Wherein the minimum qualification for appointment as teachers were laid down. Apart from other educational qualifications prescribed therein, said notification also mandates passing of teachers' eligibility test and reads as follows. Pass in teacher eligibility test to be conducted by the appropriate government in accordance with the guidelines framed by NCT for the purpose. As is clear from the above, such a TET to be conducted by the appropriate state government, that is, respective state governments, though in accordance with the guidelines framed by NCT for this purpose. It may also be mentioned at this stage that passing of the TET is a mandatory condition without which a candidate is not eligible to participate in the recruitment process for appointment as a teacher. NCT also formulated the guidelines which were forwarded, etc. Now, next, in the same as the last sentence, same para 9 of these guidelines stipulated the opposite conditions reads as under. A person who scores 60% or more in TET exam will be considered as TET pass. School managements, government, local bodies, government aided and unaided, may consider giving concession in person to persons belonging to the SC, ST, OBC, differently abled persons, etc., in accordance with their extent reservation policy. Then, my lord, your lordship will then go straight, my lord, to para 13. Lord, I'll skip all that. I'll just take your lordship to the question 3 at page para 72. So that's page 381. There were 3 questions. The third question was regarding this migration. Also, it's important, my lord, there was a policy decision allowing migration. It's a big difference. Please see 72. The policy decision was contained in the letter dated 11th May 2011 issued by the state government, thereby allowing migration of reserved category candidates to general category who had secured better than general category candidates in recruitment examination. Then, my lord, I'll skip that and take your lordship straight to 77. This is the argument which was accepted by this on the report, which is important. This is where the concession is neutralized according to this court. It was also pointed out that insofar as recruitment process is concerned, that is, my lord, the second stage, like in the TAIT examination, weightage of 20% of TET marks was given in the final score. This flat weightage of 20% of TET marks given to all candidates, irrespective of the categories to which they belong, provided a level playing field. In this manner, those candidates who had secured more marks in TET were placed at advantageous positions by giving the said weightage. The other effect was that those candidates in reserve category who had secured less marks than 60% and became eligible in eligibility criteria of TET marks naturally got less marks under this head. Therefore, as far as recruitment process is concerned, no such benefit had accrued to the reserved category candidate. 80. Alright. Then, my lord, 80. Yes. Having regard to the respective submissions noted above, first aspect that needs consideration is as to whether relaxation in TET pass marks would amount to concession in recruitment process. So the inquiry was about the concession. High Court has held to be so on the premise that para 9A dealing with such relaxation in TET marks forms part of the document which relates to the recruitment procedure. It is difficult to accept this rationale or analogy. Passing of TET examination is a condition of eligibility for appointment as a teacher. It is necessary qualification without which a candidate is not eligible to be considered for appointment. This was clearly mentioned in the guidelines notification dated 11th February.
The same notification, same guidelines apply for us?
No, all the states. This is the
our guidelines. What do they say?
Our guidelines don't give any weightage at all.
NCT will say it.
Your lordship will see that. These guidelines pertain to conducting of TET. Basic features thereof have been pointed out above. Even para 9, which provides for concessions that can be given to certain reserved categories, deals with qualified marks that is to be obtained in TET. Thus, a person who passes TET examination becomes eligible to participate in the selection process as and when such selection process for filling up the post of primary teacher is to be undertaken by the state. On the other hand, when it comes to recruitment of teachers, the method for appointment of teachers is altogether different. Here, merit list of successful candidates is to be prepared on the basis of marks obtained under different heads. One of the heads is marks in TET. So far as this head is concerned, 20% of the marks obtained in TET are to be assigned to each candidate. Therefore, those reserved category candidates who secured lesser marks in TET would naturally get less marks under this head. We would like to demonstrate it with an example. Suppose a reserved category candidate obtains 53 marks in TET. He is treated to have qualified TET. However, when he is considered for selection to the post of primary teacher in respect of allocation of marks, he will get 20% marks for TET. As against him, general candidate who secures 70 marks in TET shall be awarded 14 marks in recruitment. Thus, on the basis of TET marks, reserved category candidate has not got any advantage while considering his candidature for the post. On the contrary, level playing field is maintained, whereby a person securing higher marks in TET, whether belonging to general category or reserved category, is allocated higher marks in respect of 20% of TET. Thus, in recruitment process, no weightage or concession is given, and allocation of 20% of TET marks is applied across the board. Therefore, the High Court is not correct in observing that concession was given in the recruitment process on the basis of relaxation in TET. Once this vital differentiation is understood, it would lead to the conclusion that no concession becomes available to the reserved category candidate by giving relaxation in pass marks in TET insofar as recruitment process is concerned. It only enables them to compete with others by allowing them to participate in the selection process.
It turns out to be qualification rather than competition.
Yes. But they just be In this backdrop, irrespective of the circular dated 11th May 2011, the reserve category candidates who secured more marks than marks obtained by the last candidate selected in general category would be entitled to be considered against unreserved category vacancies. However, it would be subject to the condition that these candidates have not availed any other concession in terms of number of attempts, etc., except on fee and age. And then, my lord, para 83 is the last para that I will read. It is stated at the cost of repetition that provision of giving 20% marks of TET score was applied to all candidates, irrespective of the category to which he or she belongs, and therefore no concession or relaxation or advantage or benefit was given in this year which could disturb the level playing field and tilt advantage in respect of reserved category candidates. On the contrary, the reserved category candidates who had secured less marks in TET examinations are given lesser marks in the recruitment process on the application of the formula of allocating 20% of the marks of each. Now, my lord, only Pradeep Kumar remains to show. On the last occasion, my lord had asked me whether it's also two-stage. It is also two-stage. There is a test, the TET, and then there is the recruitment test. So there are two tests. What do you want to show? Would your lordship see para 6? Yes. Tribunal considered rival contentions and observed that rejection of the candidature of the original applicants would mean that the appellants do not recognize the CTET qualification. Relying on Vikas Shankla, Tribunal took the view that there shall be no bar in considering meritorious applicants in the unreserved category if no weightage was CTET marks in preparation of the final list. Court said that even if no weightage is given, still they can be considered. Now, my lord, I'll skip some paragraphs here and take your lordship to para 18. 17 you read. 7. Question therefore to be answered here is whether the above case pertaining to recruitment in Rajasthan, with candidates competing for vacancies in their home state, would apply to situation in the present case, where candidates from other states obtaining qualification under relaxed norms are aspiring for general category vacancies in Delhi. Lord, just then before that in 11.2, when they framed questions, Lord, in para 11, just the second question. The first question is about outside 11.11, where the respondents who have secured CTET qualification from outside Delhi as OBC candidates by availing 5% relaxation in the qualifying marks be considered for employment against the post of special education teacher in government of NCT Delhi. And the second question also was considered whether the respondents, after availing concession under OBC specifically formulated, Sorry, brother, I took your lordship's back. I just wanted.
No.
Now, my lord, para 18. Decision of Vikas Shankla was arrived at due to certain peculiar facts in the recruitment process of teachers therein stipulated that 20% of the final result calculation of every aspirant will be based on the candidate's TET result. Thus, candidates who obtained CTET qualification after availing concession had naturally secured lower marks in the total aggregate compared to those who appeared in the unreserved category and did not avail such concession in past. In those facts, it was held that the resultant reduced marks in the 20% component will neutralize the benefits of the eligibility given to reserved candidates, who thereafter had to compete with unreserved students without any concession and also overcome the disadvantage they had in the 20% component. On this aspect, the following was the court's observation. And then para 81 is quoted. Once this vital differentiation is understood, it would lead to the conclusion that no concession became available to the reserved category candidate by giving relaxation in past marks in TET insofar as recruitment process is concerned. Above excerpts reveal the court concern for maintaining equality in the recruitment process. However, in the present recruitment process, in the absence of a compensatory disadvantage or balancing factors, ratio and Vikas Shankla cannot be applied for the respondents who obtain CTET qualification by virtue of concession given to OBC categories. In other words, the concession benefit is not neutralized in the Delhi recruitment process. Thus, a level playing field and a fair treatment is not achieved by inappropriately applying the ratio of the customer without having regard to the particular fact of that case where a different selection yardstick was applied. As noted above, there was no balancing out of the relaxation for the selection process in Delhi, unlike the process in Vikas Shankla, which is CAT erroneously applied. So, and then, my lord, the lordship, please see para 20. It is important to keep in mind that the respondents are competing for general category vacancies. All others in this group have obtained their CET eligibility qualification, securing the normal pass marks without availing any relaxation of pass marks. On the other hand, respondents, despite their lesser marks in the CET examination, could qualify only because they availed the relaxation benefit in C category. Their eligibility qualification is secured under relaxed norms meant for OBC category. Therefore, we do not think it is proper to consider them to be eligible for the general category vacancies, and contention to the contrary is unacceptable. Respondents with their CT qualifications under relaxed norms would be eligible for OBC category posts provided their OBC status is certified and recognized by the Delhi government. But such not being the case, they are ineligible for the reserved category vacancy. To allow them to migrate and compete for the open category vacancies would not be permissible simply because they have secured the CET qualification with relaxation of pass marks meant for those belonging to the OBC category. As the respondents have not secured the normal pass mark for general category, their eligibility for general category vacancies is not secured. Therefore, their performance in the selection examination would be of no relevance in the present process. As already discussed, this case concerns qualifications obtained with concession in pass marks. Such concession would have a direct impact on standards of competence and merit in the recruitment of special education teachers. Principles of reservation under the Constitution are intended to be confined to a specifically earmarked category, and the unreserved category must be protected to avoid dilution of competence and merit. If Vikas Shankla is interpreted shorn of its peculiar facts, as has been suggested by the Respondents' Council, it would, in our perception, considering that respondents secure the qualification under relaxed norms, would lead to dilution of merit in the unreserved category. Arguments made to the contrary are rejected. So, my lord, in this case also, there is no weightage given to the shows actually the process. Yes, now I'll just show that to you. That's the only thing you show. Yes. So, where exactly are these SKT and other notifications which talks about both the TET and the TAIT? Yes. My lord, the first, my lord will just see the TR at page 59 of my. Which are the ones relevant for us? Yes, just the relevant ones. There is a 7th February 2019 GR which is attached to my annex to my counter affidavit. At page 59. Page 59 below of my counter affidavit.
That's the government resolution.
Yes, my lord. It's a GR dated 7th February 2019.
Where do those that also annexing are positive results?
So there are two separate ones of 7th February. I think this one is not there. There is 3 ones. I think it's different.
The one.
So this annexure R3,
put all of them together here.
What are the relevant rules? One page. But they are just two of them.
Okay, 7th February.
Yes, 7th February, page 59, annexure R3. So GR dated 7th February, my lord, and if your lordship,
what does it say?
Turn to page 60, just para 3 paras.
This GR is supposed to be reducing the passing percentage to 55%.
Yes, that is mentioned here. But first, would your lordship just see page 61? My lord will see that is the government decision. government decision, government resolutions and letters mentioned so and so. Education and professional qualifications of teachers in primary, upper primary, secondary, higher secondary schools, junior colleges in the state are now determined as follows. Then 1.1 classes 1 to 5 PCB that you have to pass the TET. Below that at page 62, as per the guidelines of NCTE, passing TET conducted by the central government or government of Maharashtra shall be mandatory. Same melod is for one only said passing 60%. That is as per NCTE says 60%. Where do we get that? That I'll show you. NCTE says 60% is passing. Where do we get that? Now I'll just take that, but before that, let me finish with this. Would your lordship see 63? Para 3. Relaxation in minimum qualifying marks. Relaxation in minimum qualifying. For the posts of primary and upper primary teachers, which we are concerned with 1 to 8, relaxation of 5% in minimum qualifying marks shall be granted to categories belonging to. And the Lord, these are the reserved qualifying marks in what? So now that is the Lord part of the NCTE. Qualifying marks in TET or the other one? No, TET. Qualifying marks in TET. Nothing is not clear. And that, my Lord, TET, your Lordship will find the notification of the NCTE. Now tell us in this, yes, it only talks about TET, that's all. Yes. This doesn't talk about the other one. Yes, now that is another notification. I'll just show that to your Lordship. So this contemplates a minimum qualification mark for TET, relaxation of the TET. Yes. This says you have to pass TET and relaxation of 5%. NCTE says 60%, so that's the standard. The open category, is there any other indication that it is confined only to TET?
When I say 65 regulations, which is guidelines for TET.
NCTET. So that is part of the SLP. That's okay. 60% is only in the GR or in the NCTE. This actually doesn't talk about it. It was purely this notification. Purely as if there is no other test apart from TET. Yes, then there is another notification. What is that? That notification, your lordships will find, that is the TAIT notification, which is at page 315 of the SLP paper. Annexure P9. 315. That is also of the same 7th February. 315 Annexure P9.
How much complicated they made simple recruitment to school teachers. Where is that binary, one after another?
Yes, now my lord, here you will see. So two resolutions passed on the same 7th February. One says that you have to mandatorily pass the TET. And the second is this one, which talks of the TAIT. Yes, that I am showing your lordship. Your lordship just has a look at the page 321, the 320 at the bottom. So, this is all pursuant to various proceedings in the High Court. And at the bottom of 320, taking this into account and in accordance with the order dated 21st January 2018 passed by the Honorable High Court Bombay in connection with writ petition so and so and GR so and so were under consideration for revision by the government, then the government resolution. In all local self-government institutions, private management aided so-and-so, so-and-so, as well as so-and-so, while filling vacant teaching positions, all candidates shall be given an equal opportunity to ensure the selection of high-quality candidates for the position of education servant. Recruitment for education servant is a translation of Sevak.
Why are you reading all that? To the point.
I'll skip that, Lord. I'll take your Lordship straight to 323. This is with regard to the TAIT.
Come to that, read that. Only of relevance in this notification.
No, that is that which says selection shall be purely on the basis of marks secured.
That's what we are looking
in TAIT. That is at page 321. In the middle, I was just reading that.
Read it, please. That's the only thing you should know.
That's the only thing of relevance. No, but your Lordship will see there are two.
Read whatever you want to.
In all local self-government institutions, private management aided, partially aided, non-aided, and eligible for aid primary, upper primary, secondary, higher secondary schools, night schools, as well as government and aided teacher training colleges in the state, while filling vacant teaching positions, all candidates shall be given an equal opportunity for selection. To ensure the selection of high-quality candidates for the position of education servant, the recruitment of education servants will be based on the marks obtained in the eligibility and aptitude test. However, private education institutions will make no effort. So this is here they talk of PAIT. Then your Lordship will just see at page 323. This is the mark. That's why I was just showing your Lordship there is no weightage to the TET. But that is a separate notification of the same day that is mandatory.
So this is the only thing relevant to us.
And my Lord, one more. I'm absolutely accepting it. We are just going left and right. Page 320, put the focus back in 5 minutes. My friend is saying, give me a moment. 323 at the bottom. The examination will be of total of 200 marks and it will consist of the following two components. And my Lord will just see 60% and 40% is with regard to the two separate parts because it's called a teacher eligibility and intelligence test. So for eligibility in the written exam is 60%, intelligence is 40%. This is SWAR. These are the marks. So I'm just showing your Lordship that there is no weightage given to the TET. So therefore, my Lord, the concession which has been secured or availed of by the petitioner is a final concession with no weightage. Just like in Pradeep Kumar. So, my Lord, just one last submission. Two notifications issued on the same day, 7th February 2019, by the government of Maharashtra. In one, it is clearly mentioned that TET pass is mandatory, concession given if you are in the category of 5%. So this is the bearing is that if you did not have the concession, you would not have been eligible to give the examination qualification at all. So he is conceding my point. That is conceding it. So that is that's exactly what Pradeep Kumar, the moment he says it is only to make them eligible, he is conceding my case. Because if there's the same thing that you are eligible, yes.
The two point is, if it's a cumulative mark, you take the first and you take the second in a particular proportion, and cumulatively you take together, then you arrive at a final mark, then it's a different situation. The other situation is that you have a qualifying mark, you pass through the first stage, come into the second stage. In the second stage, percentages are given about eligibility and intelligence response. So primarily it is on the basis of the second, which becomes the determination factor. Correct. In that determinative factor, where do they stand? They are meritorious in the determinative factor. It's as simple as that. But the Lord book, they don't get knocked out, but they were not knocked out. Knocked down in the process. Exactly like the IAS matter. May I even say before the main? May I just visualize it?
Past the brilliance of
power, then what is the new judgment that they are talking about?
I don't seen that. I don't know which judgment, but there is one more of that only says it's a condition of eligibility, nothing turns out. Just come back to it. So there is one more decision in a recent matter considered by this honorable court. in G. Kiran, my lord. Look, this is again
Read in your own words, please.
Lord, it says it again distinguishes Vijay Shankla on the basis that the Lord they have secured lesser marks in the eligibility. So just see para 3. Please see para 3 below. Dispute in the present appeal is regarding the claim of a reserved category candidate, respond number 1, who availed relaxation in the preliminary examination, but was placed higher in merit than the unreserved candidate, that is respondent 3 in the final merit list based on total marks awarded in the main examination. So just see para 3. It says what Pradeep Kumar says, but strangely it does not consider Pradeep Kumar as. So it distinguishes Shankla, but it has missed Pradeep Kumar. Please see para 3 below.
So our problem is our precedents.
Yes,
So Pradeep is not referred here.
not at all.
You to take the blame, no? As the bar.
They were probably not there.
You might not have been there. Yes, so what's the
Yes, so
bottom line?
The bottom line is the same that I was saying on the basis of Pradeep Kumar. I'll just show those 2-3 paragraphs.
Just mark us that. We'll call the site. Which paragraph you are relying on?
Paragraph 32 at the bottom, after the quoted part, at page 29. This court referred to the judgment in age relaxation cases. This is not that.
clearly mentioned in the rules.
At the bottom of that page 29,
Yes, we're there.
that court affirming the proposition of law stated, once relaxation has been taken by reserved category candidate, they cannot be considered for unreserved vacancy. Inescapably, the aforesaid judgment also strengthens the view taken by us herein above interpreting the rule that if a reserved category candidate takes benefit of relaxation though at initial stage, it will effectively amount to taking relaxation even at the final stage of selection process, because without giving relaxation, he was not in a position to participate in the main examination and to set forth his claim of cadre.
All right, it all depends on the rule of Mr. Patwalia.
Then, my lord, just read para 36. So, my lord, here,
just show the rule. It all depends on the rule. Just show us the rule. The rule is very clear. I don't think the examination is have a bearing on it. Just show us that.
absolutely not. That on page 300,
Just show us that one rule is enough.
page 321.
You don't need anything. 321.
Correct. This government resolution says selection is only on TAIT. That's it. Nothing else is considered. Page 321, government resolution.
But the government resolution, 7th February 2019,
Correct.
he says, Mr. Shyam Mehta says, there are two such resolutions.
So the other one
One incorporates TET, the other one contemplates TAIT.
So the other resolution,
So you have to show us the later one.
they are both same. I'll show both one by one. Now, the first one
You have shown us.
I have shown. Now see the other one. That only lays down the condition of eligibility. It's not a process of selection. No marks are flowing from out of that. And at page 62,
You must show us that also. Second, that he has shown us in the
page 62 is the counter. Page 62, 61, 62. Because we are classes 1 to 5 primary teachers. But I want to also tell your lordship the principle from all this, from which it comes out.
So let's complete this.
Yes. Page 61, 62. The government is in the middle of the page. It says for classes 1 to 5 primary teacher, educational and professional.
Talks only of PET.
Correct. It's only qualification. That's all. The process.
Where is show us that portion where it is talking about the requirement of PET.
PET.
No, the other one. What do you call that?
DEIT.
Show us that document.
Yes. At page 378 of the paper book, 350.
378.
Correct.
How do they finalize?
On this basis, this is that notification under which we applied after we are qualified under page 60. This is the Maharashtra State Examination Council. In all, page 3,
Wherever the portion says,
in all,
this selection shall be made on the basis of
Yes.
marks that are obtained.
yes,
TAIT. Where is that clause?
I will. That is page 386, selection process.
Yes, shows that.
Marks obtained in the examination will be considered valid for recruitment in all types of school. The recruitment will be as per government resolution dated 7th February 19.
Which of the 7th February?
I quote the second one.
Oh, wait a minute. 7th February.
The one with the
number
in the SLP paper book.
check it up, Mr.
Yes. 7th February in the SLP paper book, page 321, which says selection will be exclusively based on the marks in the EIT examination. My friend is not disputing that.
106 TNT1.
Correct.
106 TNT1. No, that is different.
No, it is not. Page 321. Please see 321.
Number is different, Mr.
It is, the number is
Different, Mr. Patwalia.
P9 at page 315. Government resolution dated CET 2015 TNT1. 7th February 2009.
906.
Page 315.
At the 386, you have this number which talks about the recruitment so and so.
It's the same CET 2015. The same number, same one.
2015 149.
Yes, correct.
You are right.
TNT.
149 at 315.
Correct.
Yes, go ahead, please.
So
Recruitment it is on the basis of this.
exclusively on the marks obtained in TEIT. So TET is irrelevant to the process of selection. And the principle of law which you have laid down is that if it is merely a condition of eligibility and not part of the process of selection, then it is not a relaxation which will stand in your. That is the principle laid down. That principle actually starts, I will put it on a page and give it to your lordship. Jitendra Kumar is the first judge. If your lordship will see, that is 2010 volume 3 SCC, page 119. That is the first judgment where this is laid out. That where it is merely a condition of eligibility. Why did Justice Sikri have to dwell so much on that marks business? Because in the case before Justice Sikri, it had also crept into the process of selection. Therefore, of Jitendra Kumar, this is 2010, volume 3, SCC, page 119, and your lordship may note paragraphs 43, 44 to 49, 43, 44 to 49, 52, 74 and 75. Here your lordship may underline paras 44 and 52. These are the crux, and the crux is where it is merely a condition of eligibility, there you can't stop them. But the moment it becomes a part of the process of selection, there they are not allowed to get transferred. So here it is merely a condition of eligibility. This judgment is then carried forward in Vikas Shankla. Those paragraphs, if your lordship wants, the ones which I consider relevant are paras 9, 13, 15, 38.3 is the issue, then 72 onwards up to 82. These 10 paras, out of which according to me 76, 80 and 82 are very important. And this is the thread underlying these judgments. It comes out of Indra Sani's judgment act. Jitendra is the judgment which relates it from Indra Sani. That where, because they say under the constitution, various concessions are given to the reserve category to make them eligible to compete with everybody else. So if it remains merely a condition of eligibility, then you can't hold it against them from transfer. But the moment it gets transferred into process of selection, then it is held against. I cannot put it beyond this law. This is the law which your lordship has given. And here, admittedly, it is merely a condition of eligibility. Thank you. Grateful. Yes, did you see that the other one? Now here, there you saw this one. Yes, I've seen. This is an IAS recruitment under the Indian Administrative Service. Here, the preliminary exam is part of the process of selection. You are shortlisted on the basis of the cutoff marks obtained in the preliminary examination. So once you don't make the cutoff of the general category, they didn't even pass the prelims. Correct. They did not even. They were not good enough to get shortlisted. They got a concession. That's not a condition of eligibility. That is a process of selection. And Vikas Shankla in this judgment has been distinguished only on this ground, saying that there it was a condition of eligibility. Here it has become a part of process. This very judgment distinguishes it in that fashion. I'll show that paragraph where Vikas Shankla. That is para 35. At page 32. So far as Vikas Shankla is concerned, it involved recruitment to post of teachers, whereby relaxation in minimum pass marks in teachers' eligibility test was granted by the state government. Various candidates belonging to general category came before this court on the ground that minimum qualifying marks and relaxation meant availing relaxation pursuant to reservation, and thus migration of candidates who took benefit of indicated reservations was impermissible. The appeals were allowed with the following observations that is quoted. Then, my lord, if your lordship will see, therefore it is clear relaxation in TET was not considered to be a concession. For this reason, the judgment is distinguishable. And then 36 is also. But the bottom line is every case will turn out on its own facts. Correct. But the bottom line is not in their own facts. Yes. Depends upon what exactly the rules. But the bottom line is, if it remains a condition of eligibility, then you cannot stop migrating. That's the principle. That's right. Now, my lord, the fact that it is a mere condition of eligibility has also been stated by Justice in a recent judgment in 2025. Just pass on to book. This is paragraph 202 to 206. where they have said, my lord, that it's a minimum qualification which is eligible to make you eligible to compete, etc. Actually, my lord, the three judgments are Jitendra Kumar, Vikas Shankla, and this Pradeep. They are the only three judgments on the point. Actually, Jitendra is the one which lays down the principle of the issue. The principle will depend upon how you formulated the rule. Correct. If it remains merely in the realm of eligibility, you cannot deny migration. That is the point. Now, my lord, Pradeep was interlaced with the fact that they were from a different state.
Use that judgment.
Yes.
Use reference to the minorities being
correct. So this
referring to the larger thing.
Pradeep is interlaced with the fact that they were outsiders in the state and therefore they were not eligible. Great.
I have three IAs in the matter. We were original writ petitioners before the High Court, and here performer respondent, we were deleted. I just requested to implement me as a party in the end of saying.
Yes, sir.
Thank you.
Great.